Generally, to see that justice is done the sake of appearance to the general public, judge be prohibited from any activity in a case. At issue is whether Judge Owsley should recuse himself from the case. Purposes contemplated contempt procedure litigation in the case any second. Since the case was remanded by the Louis, statutory grounds for recusal are grounds for recusal of judge in a criminal case. The judge biased, prejudiced, or personally, the judge would be unable for any other reason to conduct a fair and impartial trial. In a criminal case, the judge from conducting an aspect to cause an affair. Recent subsection was added as legislation amendment, Supreme Court post-amendment reversal of owner. We find based on the objective, impartial manner considering these unique facts, the interest. Denied decision, State v. Nouveau. Judicial canon responsibility of recusal portions. A judge shall avoid impropriety and appearance of propriety all. A judge, as used in the Code of Impartiality or Impartial, denotes prejudice in favor or against parties or class maintaining in an open. Canon 3, a judge shall perform the judge's duties. Judge's duties, the following standard apply: adjudicative responsibilities. See Code of Judicial Conduct. A judge shall perform judicial duties without bias. A judge may make reasonable efforts consistent with the law and court rules to facilitate of all against recusation. A judge shall disqualify himself in a proceeding in which disqualify himself. Supreme Court rule, right to a fair trial. The right to a fair trial enshrined in the Sixth Amendment, further codified in federal, state, and judicial canons of ethics reasonably be questioned. The ground for recusation in this motion fall under the Article 4. Louisiana Code procedure in a criminal cause, conducting any aspect of the cause of fair, may also due process may sometimes bar trial by judges who have no actual bias and who do know that bar. Consider objective upstanders requiring recusal not consistent. The greatest self-sacrifice could carry it on without danger of injustice. Every procedure which would offer her might lead to latter due process of law to me first state. The recusal from Canon 3C, the judge's SCOTUS merchants, and whether or not it's actual bias, the tolerance of the judge or decision maker is too high, constitutionally tolerable. Diego Ripple, judge or decision maker is too high to be constitutionally tolerable under Ripple's mandate of actual bias. Necessary require recusal in a constitutional appearances of bias. Secures appearance of bias. Number 1. When I consider the sentence, I'm supposed to look at the statute, either imprison or suspend a sentence. From the beginning, the state structure, when the defendant had been convicted of a felony or misdemeanor, the court should impose separately discretion of the court. The judge then proceeded to incorrectly blend two sections of A and B rules, whether or not you're going to imprison. The state 984.1, the judgments as demonstrated by the decision-making section B factors the statute section A accorded weight in the court's determination of suspension of sentence probation. The judges continued A1 right off the bat. Number 1, there is an undue risk that during the period of suspended sentence or prohibition, in applying the sentences guideline, there is undue risk that during the period of suspended sentence or probation or commit a crime, probably because apparently circumstances in finding A1 assume probably would apparently possible. The citation formats Heinze would challenge the local authorities. Undue risk. The undue means excessive in context of the statute. The judge's consideration of the Section A factors supporting a sentence of impoverishment should have been completed. The judge should have determined. The judge, one more, after extensively discussing factor B7, the judge factor in the sentence maximum. The judge incorrectly applied factor B7, which we are more concerned. The defendant did not contemplate that his criminal conduct would cause the threatened serious harm. This lacks communication of the record of consideration of other applicable factors presents the appearance of bias in the judge's application of the sentencing guidelines. Despite a failure to articulate on the record during sentencing of consideration of factors, the judge appeared to be aware in an earlier pre-stage. Judge, the problem I'm having is that you have violent crime sentencing, given the judge's early pretrial recognition of the incidents not being violent. Number 1, the trial judge applies sentencing guidelines incorrectly to the detriment of the defendant without considering mitigated factors shall be accorded weight. Appearances of bias use extrajudicial information. The circumstances is challenged. No specific evidence introduced in a hearing. Contention that Mr. Heinze put himself in challenges. Furthermore, there would be no evidence during the proceedings support the contention being found unaware. Extrajudicial in the case of the source of information as unknown. The defendant, with his assertion of extrajudicial source of which overlooked by unknown, regardless, even if hypothetically speaking, Mr. Heinze had deliberately put himself in such circumstances where their language authorities as citizens are free to protect themselves, freedoms, a nation's founding documents is a cornerstone of all other freedoms. Non-criminal conduct of challenging local authorities is constitutionally protected activity under the First Amendment. To view protected criminal activity, defendant will commit another crime, and the reasonably likely constitutionally protected activity different from the outcome give rise to the appearance of a bias. Appearances of bias is 3, includes more of a sentencing, determination of suspension of a sentence or probation, and number 7 days are outcome of this criminal proceeding. The implied B7, the judge continued, there is no doubt that this has occurred. I can tell because the court has been contacted. The clerk's office, these are not good things, and you said I don't tell people what to do, and I said, well, it would make sense. Contact the judge. States you could easily public forum, bring people back. I'm elected official. People are going to throw tomatoes at me. It's part of the job. I don't care. I don't have it for individuals who do nothing but service a library. That's wrong. And your followers. It actually got worse. Right, that's increased emphasis added. The judge then concluded that the factor is in your sentence. Throughout the entire pretrial and trial proceedings, no evidence forces outcome, criminal procedures, no documentary evidence, threats or harassment, emails of disgust. Travis, his followers, and other specific described threats and harassment with no evidence, and thus contact the judge could initially conclusion and conduct meant a description of the offense. The offender use or contacted other judge could only believe that the factor B7 was meant by believing that Heinze was somehow responsible for the threatening that things need to be done and consistent intent to influence the institution conduct. Appearances of bias is number 1 of allegation accused and opportunity to rebut. Audio recordings and the described behavior and unbiased judge unstated behavior. They are named adults to influence sentencing. Why not conduct law enforcement? See the transcripts. Judge, how about that? So maybe they're a little more trustworthy than the person that you don't know on the internet. Furthermore, if any of the activity described in the court has been contacted, the office to be done, the things judge could have enlisted police and prosecutorial investigative level of criminality, and the fact that such actions have been stated, we have serious concerns that this might be something that detectives get involved in to determine whether or not any laws have been breached. Not for their judge. The judge responded there today, Mr. Courts, in witness intimidation. It's not even at the pretrial stage before sentencing in this case. The judge's response to the prosecutor clearly indicated that he was not aware of stated felony charges of witness intimidation or related crime against any person, yet the judge acted against the guided, never even charged, outraged members of the public, harassed various. It's extremely possible and nefarious online to discredit, harm Mr. Heinze himself, criminally harassed or threaten anyone. Billion of users. He had no legal duty to YouTube videos related to the alleged offenses. New views. Sample of users apparently unilaterally. You named individuals connect him to such threats, adults how to behave, no specific events, city court or any. So whether you intentionally egged it on your sentence, in this indication you had no evidence of intent, sentence the improper and detrimental applications of this introduced and specified and corroborated evidence. B as to what bothered me. Evidence give rights accountable. See, for example, the following media, my legal problems and nakedish videos. Judge, do you want me to hold you accountable to other cases? They have nothing to do with you. Your case is your case, and that's it. My thing is, why not take your platform, your effort to lay off people? Why not? This concerns is magnified in the bench trial. Appearance bias number 4, sentencing contrary to judge's pretrial statements, implying factor 8941. Will it take fast enough? Okay, you didn't. You told me you wouldn't because that's your position. Well, that's your choice, but I think it's despicable to do that. Individuals actually gets worse. Then there's more calls egged on, intentionally egged it on, and refused to stop it. This is interest that right after that it increased. Emphasis added. The judge then concluded this is a factor in your sentence. The judge's decision to impose a punishment on Heinze's judge's stance during the pretrial, March 21, 22. Judge, I say more because I already gone the harassment whether or not to help us March 23. My position again, I'm asking if you feel like it in order, feel it necessary to maybe share with your followers that it's unnecessary to have any attempt to intimidate or harass people. I'm not in double, but I'm not suggesting you have anything to do with it unless you think it's a good thing. Why not reach out and tell them to stop trying gesture? I'm taking a neutral stand on this. I'm taking the middle ground, sir. Yeah, that's it. That's my answer is my question. That's fine. You do what you wish. Heinze could only rationally take the judge at his word in the March 21. Rationally had no reason. A hidden meaning. A judge cautioned against words with hidden meaning. There's serious, really, okay, not everyone gets that. Yes, not sarcasm. Sometimes goes over people's heads. Transcripts might correct in leaving the March 21. Heinze's refusal to tell others what to do. After all, during the March 23, 22, Heinze's position between the two layers of bread. I'm asking you if you feel like it. That's fine. You do as you wish. I'm between the bread layers as the meat. You search your choice. It's America. Apparently, when what to do brought the judge's response. That's okay. That's fine. You do as you wish. The judge was not expressing that Heinze was recommencing the crime of neutrality. The judge appears to be expressing during the sentencing. The judge reversed acceptance of Heinze's court handling this proceeding. The judge erred at sentencing, recalling specific language that was never entered in any hearing when it recounted back off. Similar to the court order, it would appear something influenced the judge to err in recollection. Articulates acceptance during pretrial hearing position detriment to the defendant's journalist or appearance of bias magnified, but more appearance of bias. Number 5, irreconcilable dismissibilities. The finale rule that defendant's constitutional rights to be represented. The two findings are related. The finding among the sufficient evidence were two categories. Undersigned counsel discussed these evidentially recurrent issues in the writ. The first, during the trial, the city prosecutor objected on relevance of ground and attempted cross-examination by the defendant. Heinze on the obscenity statute and its relation of alleged computer display of pornography, and sustained subjection. Heinze in the seizure of computer display of pornography. Investigation. Notably, Mr. Heinze was acting as a layman, as a professional of a lawyer when trying to do at 250. However, any accidental display of pornography would have been criminal. The crime, no defense of obscenity. One needs only to read the obscenity statute, as Heinze was trying to get Officer Davis to do, to see that intentional through sexual events. However, Heinze was never arrested for any sexual crime in relation. Davis even mentioned as pornography displayed a factor reasonable suspicion or allegation was reasonable line of inquiry. In any event, it was obvious that there was areas of sexual offense. The whole purpose of Heinze attempting to cross in Officer Davis indeed believed that Heinze intentionally displayed pornography, and perfect legitimate since the prosecution's witness had testified. Davis in one aspect was shown that pornography never had any attempts to impeach Officer Davis in the pornographic computer display testimony. Evidence of pornography, according to Mrs. Parker, that saw our own eyes and in the business of self, that it's by itself. There's something patently unreasonable about that, patently suspicious testimony that's deduced here in this particular court. That alone, if we put everybody else aside, that alone just causes suspicion. As to 50 above, the judge overruled any objection of Heinze's. Heinze indicated to the judge, I made arguments about the totality of the circumstances. The judge responded, you were asking me that related things that led to your reasonable suspicion. That was a factor. Fear of the staff and kind of stuff. And so he's saying what led to the reasonable suspicion you were trying to, whether you charged for the reasons mentioned in the preceding paragraphs, the trial court was wrong in this analysis, while perhaps not dispositive of either. Cross-examination need not be dispositive. Fact finders taken into custody under Louisiana Code of Evidence Article 607 evidence contradicting probative value, the risks of undue consumption, the legal standard of the weight requires parties credibility, the risk of undue consumption, emphasis added. Louisiana Code of Evidence, Louisiana or other legislation, evidence, relevant evidence, meanings evidence having any tendency to make without the evidence, implicitly recognizes that one can attack credibility substantially. Must occur almost exactly. It was only fair to allow Mr. Heinze, an unrepresented defendant with the latitude pornography allegation, was unreasonably litigants, including that the judge should not have given representative on cross-examination had Heinze been allowed to present the obscenity recovered from the computer, in contrast to his restrictive stance in his prior trial rulings. Beautiful kids in our community around and our children. Their expansive reference to partially suspicious. The incident occurred on a Saturday when very few people were in the 3 of the 4 patrons in the second floor. That's what Heinze is to be believed, and there's likely 3 or 4 patrons in the second floor. There was no evidence. No one testified the children were on the second floor without supporting recording evidence, and he brought judicial reliance on the suspicion. This liberal use of assuming children are near Travis. Trial in closing, but argument is not evidence based on the facts presented at trial. Children should not have been used in any evaluation of sentencing. The judge made pretrial rulings regarding that evidence. Additionally, Heinze objected to the relevance and interview of Rosalind Parker. Legally, largely reasonable officers. Librarian interviews occurred days after, at the time of stamps and due test stamps. Detention or arrest are legally irrelevant. Furthermore, any details of the interview, same as testimony legally. One looks at the videos. In fact, Heinze was asked under cross-examination. Heinze reiterated at trial by his own admission, admitted at trial verbally that all statements made in this post-arrest by officers prior to the arrest, determining whether irrelevant, especially Heinze's video, didn't communicate with the officers at the time of the encounter with Mr. Heinze. None of your unarticulated thoughts. Instead, Heinze's detriment to Heinze retrial proceedings, competent counsel to strongly to recuse this evidentiary issue were in the interest of the economy. Once it has decided that convention on the evidentiary rules, Mr. Heinze arises as an objective observer. Heinze's guilt supports the previous verdict. Recusation, such is not necessarily the case in a jury trial. State remand. I could not find the Louisiana state case law squarely on the subject of remand. This apparent absence should not be surprising. Littleton and Manning, bench trial judge. Note that in our case, Judge Owsley self-recused consistent with this intuition. Summary examination appearance of bias. The third court was filed better understand the investigations, free to exercise vast sentencing. Negatives who were originally charged drunk driving offenses, the same prosecutor sentenced Judge Owsley samples. In fact, one of the individuals, Chantel Collins, domestic abuse, disturbing the peace, public intoxication. 2 others, Judge Robert Owsley, then received a fine and total of 411 travel costs. Chantel Collins charges being the same charge resisting an officer in Heinze despite having other serious charges. However, Mr. Heinze's fine involving an alleged failure and some of the other example defendants who have engaged in this motion, the judge had discretion to impose different in these cases. Arrested on violent drunk driving, failure to provide his name against Mr. Heinze when judge imposed strict sentence. Bias arises from prior investigative work with all facts mentioned of the events described a reasonable suspicion. Heinze believed the officers his name, and Heinze believed that such arrested Heinze less than 3 minutes. Are his YouTube channels discriminates? His journals through the internet, body cam video from librarian Rosalind Parker, and million collective views, exchange IDs, phones, and complained people who made phone calls prosecuted for resisting. He published evidence about police from this huge group, and the librarian insulted her without showing every document transcript of a hearing. Judge, I would like to go on record. Bill of particulars. This is the entirety being indicated here. Here it is. 2 days before the scheduled trial date, Prosecutor Clay Benjamin requested interviews of librarians. My legal problems with Natchitoches. See budget travels. See let's exchange. Heinze would publish the videos. During that hearing, the judge admonished Heinze for the phone calls. I'm asking if you feel like that's your choice. Disclosure of evidence. The main theme here is that Judge Owsley and Prosecutor Benjamin will go further with that and looking into charging me. I had to spend time taking notes from 2 extra testimonies on videos. Benjamin hid these videos, and he sprung up on 2 days with Judge Owsley's response. It might revealed later my prosecutor possibly that he can try. We decided upon. I had pulled the biggest trick with testimonies reported on the hearing for over a month from being published. Many viewed that Heinze is being treated unfairly. YouTube comments placed full blame on Heinze. YouTube comments detractors of Heinze receiving more complaints was the judge. Prosecutors motion filing suffering personal anguish as a result of contact for the librarian. I thought it was wrong for her. The judge took a personal interest in the librarian's suffering. Something changed from the judge's reservation. I think this is despicable. The librarian now appeared to hold video displaying librarian's direct testimony, post-arrest statements. Fourth Amendment. The judge's appearance of bias focused instead on justice for the librarian. Based on the judge's previous appearance with this judge, standards for a motion to recuse, the court also asks not whether a judge harbors objective matter, whether this is unconstitutional. The language is not harsh. The language also expressed vindicative women suffering at the hands of unfairly caused man responsible for that woman's suffering. Concerns for the librarian should reasonably expected to appear. The implication of Littleton, Manning, and Wilson. Previously, these concerns of bias rulings on motions and objections make filing, even if there are no ill intent, afflict all human beings in the ordinary. Confirmation bias unconstitutionally, even if possessing, possibly overlooking a retrial. The initial verdict acting in the light of the new evidence or arguments. Positive or negative impressions form perception of witnesses. For instance, a good impression of first bench presented by the defense interested defendant's effect may be present on the bench. Prosecutor's theory referred to a potential cognitive bias ranging from confirmation, thinking fast, confirmation to interpret new tendency to over-rely on about a given topic. Texas Brines argues thereby creating a potential for confirmation. Any questions of bench trial, whatever the reason for a retrial, attorney presentation has identified a right to counsel reason, a lack of legal counsel contemplated, had control to find fairness in a second prosecution, judge acting in the manner of law and adjudicated. Furthermore, it is no secret that defendant Heinze had engaged in extensive public criticism of Judge Owsley's ruling. Diatribes triggered to due process, judge public lambasting to the recusal analysis. Owsley may interpret Heinze's extensive public criticism with some construe, hindering the defendant's ability. Personal attacks by the defendant's subconscious bias when the judge was bombarded possibly of a fair and partial retrial to avoid even the appearance of impropriety. See, for example, the following YouTube. In summary, defendant believes that the recusal of Owsley from all proceedings in this case is warranted. A reasonable and rational observer would expect Owsley over a second round of confirmation anchoring, favoring evidence, Heinze's extensive public criticism, objective and conduct, including a defendant whose liberty is heard, evidence, and been exposed. 4th through 9th, Heinze has demonstrated 6 appearance of bias. He believes that recusal is warranted to avoid any appearance of impropriety or unfairness and thereby ensure a fair retrial.